about human behavior being, uh, I, Bernie, say to you, Janet, but I owe Sarah $10,000. You later on, Janet, might be called as a witness by Sarah to testify as to what Bernie said. The question is, well, isn't that hearsay? Bernie's not on the stand. And the answer is, well, yes, but why would Bernie say something that hurts his position and that he was aware, he had to be aware, any person, any reasonable person would have known. When you say you owe $10,000, you're hurting yourself in the pocketbook. You're admitting a debt that you owe someone. So the law says those things have a lot of reliability and trustworthiness. People say all kinds of things that are good for them. Sarah owes me $10,000. That doesn't come in. There's no reliability and trustworthiness for that. That's me huffing and puffing and trying to, brag about something. But where I say something that harms my position, there is a good substitute for the right to cross-examine. One of the this is okay. It's a rule on hearsay, and it's called the hearsay exception for statements which are declarations against interest. And that what it has to be is the person at the time that they're speaking has to know, or any reasonable person in their position would know that what I'm about to say is going to hurt my position, but I'm going to tell you it anyway, which we then say, that's good evidence. The general rule is that if people make statements against proprietary interests, which means, Janet, see those back 40 acres on the piece of land I live in? I don't really own those back 40 acres. That's a declaration that hurts my ownership or title. I don't really own the wristwatch I'm wearing, Janet. I'm just really borrowing it. That's a declaration that I don't really have the highest property. There are declarations also called against penal interests. Janet, I really committed the murder. Well, nobody would go around saying that ordinarily, except that it would be true. It's one of those things that hurts you. I really got the plans for the bank robbery. You wouldn't say that. So even though I'm not available, and you're repeating that, I said, the exception that would allow it to come in, even though you can't be cross-examined meaningfully about the contents of my words, because you only know what I said. You don't know the reality or non-reality. That the test is, well, look, if Bernie said something which would obviously be detrimental to his penal interest, exposes him to criminal liability, then that's an exception to the rule the ordinary can't have hearsay. Well, here's Helena Stokely. She's telling people, I was there. But I didn't murder those people, but I was there and I held the light. It's clearly evidence making her a co-conspirator. She's there at the time and apparently on the surface, aiding and abetted by the crime by holding the light. I knew what those people were doing. I was there. I went with them there. A whole series of statements. I saw the children. I didn't really kill the child. She was very clear about not doing the act herself, but her statements were clear enough that says, you don't have to do the act. If you aid and abet somebody in the commission of a serious crime, you're as responsible for the crime as the actual doer. Maybe you get a lesser sentence than the one who puts the knife in or uses the club on the baby, because we then distinguish between degrees of culpability. But nevertheless, that was clearly an admission against penal interest. Now, the one caveat to that rule is that the only way you can use a declaration against penal interest, because it's so serious, that we want to make sure that the person who said it is not available. The preference of the law would be to have the live person on the stand make that admission. Now, suppose they're dead. That's unavailable. Suppose they're out of the country. They fled the country. They're unavailable. One form of unavailability specifically set out in the rules is suppose the person either has no memory or feigns no memory of the event. The law says that's unavailable. You're making yourself unavailable to testify. And Helena Stokely got on the stand and said, I don't remember where I was between midnight, February the 17th, and 4:30 a.m. of February 17th. So she claims no memory after the operative facts. That fits within the rule that says the witness is unavailable because she says she can't remember the event. Therefore, anything that she said to other people, which she admits, the kind of admission that only a sane person saying that would never say it, but that was true, then you may have other people testify. We fit all those criteria to a T. The judge then invents this little thing about only a reliable person can say those things. I've already told you my view of that. One other matter, one other rule of evidence which is worth mentioning. The overwhelming principle of evidence, the guiding fundamental rule of evidence today is that everything that is of importance to deciding the outcome of the case should come into evidence unless there's some very specific rule that countervails it. That is, I may say to you, look, I really did bump into your car, but I don't think I should have to pay you $6,000 for your damages. We never settled the case. You go to trial. So I want to now offer evidence that Bernie admitted to me that he bumped into my car. It proves that I'm right in the case. The law won't admit it. Why? Not that it isn't relevant to understanding who's at fault. But how will Bernie ever have a discussion to settle a case? How will anyone talk about settlement if everything they say in a good faith effort to settle the case is going to be used against them? So one of the rules says relevant things that are said in the course of good faith discussions nevertheless can't be used against people. Why? Because the law has a higher priority to encourage settlement discussions than it has to have you make your case to prove against me easier, Janet. All right. The rule is you have to have a specific exception, specific, rule that keeps things out. One rule says, well, if evidence is really unduly prejudicial, unfair to the other side, it has some relevant value. In other words, it would be useful to know about it, but it also is going to unleash hateful feelings against the person. Cause the jury to begin speculating about things that are remote and peripheral. It's going to get them off in a tangent. That can be used to keep it out. In this case, that's what Judge Dupree did. He said, one, she wasn't reliable. And therefore, to have a non-reliable witness's statements repeated by 9 people would be unfair to the government. Well, what the hell's unfair about it? These are people who are at admission. They didn't beat her up. They didn't twist her arm. It's a catch-all rule that says the judge can decide in his discretion something is unfair. There are very little in the way of criteria. It is essentially a touchy-feely thing to be done by a sensitive judge engaged in what we call a little balancing process, the pros and cons of it. So he says the government will be prejudiced by it. Every goddamn thing we told the judge the government was doing, such as the pajama fluky experiment, be unfair under the same rule. No, I think I'll let them do that. He could find nothing wrong with anything that they did. We could find nothing right with our protestations about it. So he said, and it's really extreme that when you have a defendant on trial on a serious matter, you really want the case to be decided on the relevant evidence. And to take a marginal and objectionable piece of evidence and use them against them, you really shouldn't do that. You ought to convict the defendant on good evidence. But to say on the other hand, that somehow the government, which is not on trial, can be unfairly prejudiced because the defendant has some evidence that someone else gave admissions to being involved in the crime, it's unheard of. That's the way he decided that case. So we lost that major leg. Number 2, psychiatric evidence. It has been my belief. Can we get you something?
I got it clear.
It has been my belief from the very outset that any juror. Can I get you some pants?
That's what I like to, but
You have some in the cafeteria, maybe?
okay.
That any person, any juror, any judge listening to this case has got to so almost early as possible hearing the kind of crime it is and the hideous to the children and to the wife. I mean, the 2.5-year-old, 3 different weapons used, 2 different knives, a club. The wife, 4 different weapons used on her. The other child, 3 weapons used. I mean, multiple weapons used on one unresisting, fragile human being, flesh and blood of this man. You have to say one thing, but it's the same. Something really wrong with this person. And I believe that's true. To the point I made earlier. There are few crimes that occur outside of their context. And part of the context of looking at this crime was say, be able to do this killing of the children at least had to require a very disturbed person. Have the hypothesis. I ran the hypothesis by every forensic psychiatrist I knew. There isn't one that could say otherwise. All said the following.
Thank you so much.
My apologies for the limited resource. They all said the following. Look, any adult person could kill another adult person and not be insane, mentally deranged, or otherwise sick. I mean, if someone near and dear to you is under a life-threatening attack, you could perhaps kill that killer, and you would not be insane. But cannot kill your own flesh and blood, infant children. without having a severe distortion of personality. I mean, I use that as the most modest term. And of the magnet, and that once you had done it, the residual of what is left inside in terms of emotional scar tissue is very substantial. And every psychiatrist, and properly examined, there shouldn't be any doubt that you'll find the indicia of this. And that was my hypothesis. I thought that one of several things that happened. Either that he was literally insane. I mean, it's just simply completely deranged, had no competent understanding of right and wrong, and did this act, or that he was a psychopath, seemingly okay in 90% of his life, but 10% the disease hidden corner that burst out, that it was a psychotic episode, the one great explosion, the years of pent-up anger, hatred, and frustration coming out, or there was a drug-induced episode brought on by drugs. And then I checked for all of this. And every psychiatrist, including the government psychiatrist, in 1970, when this thing was fresh and the trail was warm, included the same thing. There's no evidence of mental illness existing. Healthy outlets for emotions and feelings. No evidence of after the effect, shock or distortion of personality that would go along with a monstrous kind of act like this. Psychiatric evidence was an overwhelming, clean bill of health. And it was improbable, and stronger word were used, that he would have killed his children. Well, I thought to myself, this is, we eliminated the drugs contrary to Joe McGinnis's, absurd theory. We eliminated alcohol because the medical reports eliminated alcohol and substances that just stayed. I thought it was critical to introduce in the trial. There were a number of different evidential theories taken to put it on. You know the story of the judge, in a sense, sandbagging us, saying, well, I really won't consider letting it on unless you let the government have another exam of him now. They had examined him in 70, this is 79. And, as painful as it was to have to give the government something when we couldn't get anything from them, such as the physical evidence. Nevertheless, I thought this is so important, and that the videotapes had not been introduced. We tied for that too, to introduce that. And you had this panoply of psychiatrists that had seen him off and on since 1970. He had a very credible display that was so important that we agreed to it. The upshot of judge under 403. The same rules that, well, it would be unfairly prejudicial to the government. And the government is not on trial for its life, but the judge has only one concern, that they will be prejudiced to defending put on the defense. Out the window, the second leg goes. The third leg of the defense is to show that the forensic evidence is really fraudulently arranged. It was put together in a method which has been subject to considerable criticism, and Jeff Elliott, I know, has given you probably, and I hope he hadn't, if not, I'm going to use the person you might want to talk to, Dick Fox. Others, have looked at the evidence, and everyone agrees. And then I think people have some measure of respectability in forensic science too. That this is some of the things that were done by the government represent the main props case represent pure fraud. I mean, they are not scientific. There are no support for it. They're things that just would not be offered as scientific evidence, and they got away with. More important with that, not only the government, we wanted to be able to show what was going on. I told you the 29 document story, that we never got the physical evidence from the day the case began till we were within a few weeks of the trial, at which point, when finally we were allowed, after 4.5 years trying it, the judge, there was no time to do it. The government would not let us have it. Our laboratories, we had to stand in their laboratory with them looking over our shoulder, where we never had any chance to observe them. I mean, it was a fiasco. Our people said, we can only do a handful of things. You've got more than 2,000 pieces of physical evidence, all of which should be examined in its total context to see whether it adds up to apples and apples, or whether it's apples and oranges and pears. We can't do anything for you now. We're relegated to a few testing items of things that we had thought might be critical, never got to see and examine the most critical things, and never got a chance to expose the fraud, which today has been written about by forensic scientists, that basically this is not it. The fourth thing, that was the fourth leg of the table, was the report of Colonel Rock. the the officer who presided over the military proceeding in 1970. What we proposed to do was to offer his report to the jury that said this case was investigated while it was fresh. But aside from the hokey experiments, which are not new evidence, it's just ways of rearranging things, the jury ought to know that after the longest, most extensive, and most thorough proceeding of its type in all of military justice history, with the most well-founded report record, that he found that the charges were not true. Those are his official words. And there's a specific rule of evidence, again, that says that in a criminal case, one way a defendant can defend himself is he may introduce the official report of the government made in any other investigation, which vindicates him. In other words, to show that the same authorities that now claim he did it have on other occasions concluded otherwise. Once again, the judge said, in the face of the rule which makes it clear, it would be unfair to the government. What the fuck? The defendant get, we never had our ruling sustained under 403. Where does the government get itself on trial that it weeps to the judge that it's unfair to defend as a defense? We then find ourselves at all four legs of the defense table court shot to smithereens. And the judge himself made the observation in trials. I don't know what this is all about, he says. But put the defendant on the stand. Let him tell his story. This moron with his fender bender cases. I don't want to quote me as saying that moron. It's inappropriate for a lawyer, the public press, to say the judge is a moron. I may say everything but short of that. His view, and that's why I mentioned earlier what we knew about his background as a practitioner. Nothing was ever complicated, difficult. It's all the back of my hand. Says, put the defendant on, tell his story, that'll be it. When he put Jeff on the stand, he permitted him then to be cross-examined. In the face of our objections about improper examination, 403. Well, how do we know you didn't do it? They asked. How do we know you didn't do this? And questions, rhetorical question, not question calling for fact or for information. I mean, shamble. They were allowed to perform this hocus pocus demonstration. He said, well, the demonstration didn't relate to the fact they're allowed to do it. Well, couldn't this be so? It was an utter debacle of the type I have never seen. Not that it's my case. I wish someone else had a worse case. I might then take pity on them, let them cry on my shoulders occasionally. I could cry on their shoulder. Never saw one like this. Unbelievable. I thought there was so much error in this trial that we could have, we used to kid around, that we could cut up some of the errors and sell it off to some other poor defendants who didn't have any error in their trial. And we could sort of go around, free some of the unjustly accused by giving some errors. We did not reckon with the fact that this was the fourth time McDonald case with the front of the U.S. Court of Appeals for the Fourth Circuit. It had 3 times before it sustained our position, and 3 times it just kicked right in behind it. And the court was sick of it. They were sick of the case. It's as simple as that. A court does become frustrated with the case. It says, look, this man has had all the shots he can, and jury convicted him.
Why did they repeatedly reverse?
Supreme Court was bound and determined not to permit. They didn't care about McDonald. Supreme Court really never cares about the particular case in and of itself before. The unique role of the Supreme Court is to look at overall impact on the judicial system. And they had this. First of all, in the first McDonald case, nobody should be allowed to take an appeal before their trial if they raise a question of whether they've been denied a speedy trial. Every defendant will delay his trial by doing this. A spurious argument. There are few defendants who have this argument that we had on delay of 4.5 years. Negligence, sitting on the case for 2.5 years doing nothing. They're just, it's a handful of cases. But the Supreme Court now managed to get itself whipped into a fury. Oh, no. They'll all be doing this. Therefore, now we're wiping out his right to an appeal and one before trial, this issue. Then we go up after trial, reverse it again, goes to the Supreme Court again. Oh, no. It was okay for the government to wait, 5 years to within 3 weeks of the ending of the statute of limitations. It's all right. They have to have all the time in the world. The fact the file sat in their office for 2.5 years and nothing was done, not a bloody word was done on this thing, because nobody knew what to do. And There was nothing there. There was a CID report. They have to be allowed to do this. This is in the greater interest of the public. Just throw them again. We're back in the Court of Appeal. They were sick. We tried to help them. And the jury convicted them. That's the end of it. We won't look at anything. They made nothing of all these enormous trial errors. It was a very bad decision, not because of my case. I, recognize, once again, that lawyers and judges can disagree. People of good faith can come to different conclusions on cases. In this case, this is appalling. There was no defense permitted except to get on the stand and then on the stand be able to pillory the defendant with questions which the jury figured they're allowed to ask. It must be right. Why wouldn't you do this? Tell us why you wouldn't kill your family. Good Lord. Absurd things. So the defense came away with just the most outrageously unsuccessful track record you will ever see. I don't know the case where the defendant could get one of his four major legs of his defense up, and then his own testimony just absolutely belittled in every way.
You make me want to read that faster.
You're welcome to. I hope that if you read the transcript, you will start with that hearing before trial in which the judge lacerates me for saying the government, of the 29 documents here, the government has misled the court. It's a fraud, and the court simply never asked. You start there. You see what is going on. The only thing you won't see the transcript, and you won't see the smirking and the judge in the back of the hand. But you have enough of it, and you can hear the judge's voice booming. I don't know whether we probably didn't transcribe the jury selection. I wish you had it might be there. I don't remember that. Transcribe that. Got to read the judge telling this black woman to go back and pick tobacco for her father. I mean, talk about a racist attitude, sexist attitude. Just awful stuff. Anyway.
Now, you don't have that in your files anymore.
No, most of my files are with Jeff. I have some things. I have probably things from the military proceedings because nobody wanted those. And I guess in due course, I'll send them down to Donna, Bruce to keep theirs. So we just keep everything in one place. I've kept them for historical records, my own interest in military proceedings, military law. But I might have the videotape. So that's the other thing I have to look for you, Jeff. Craig, my bar pen.
Oh, okay. Back.
What's all right? These are my own pens in the back, right? It's one of my notes. Yeah. I rest my case. Pen costs a lot of money. I just wrote you. Thanks. Oh, let's see.
Well, I'll take the girl voice.
And Donna also. Yes, yeah. Well, between them, I maybe Gail is the custodian. Donna's been doing the indexing, but I'm not sure. I'll take a look. I may have the videotapes. I'm not sure.
But about that, I mean, whoever has it was just classic for the borrow it. So
Yeah, it's 4 of the most painful hours that anybody will ever see. I mean, when I think of a psychiatrist coming out with tears inside. I mean, not one of us. I say one of us. Those who worked on it for a long time, and had, very close takes with this coming on, looking at it, just being boggled by it. Sometimes, something that it would make.
I get you like a thought. Oh, I'm also talking about getting scripts.
Trial?
Yeah.
Oh, yeah. That I think is. I know I don't have that.
Yeah.
That was given all entirely to the folks. Yes, I was sure. And there's no problem you're reading it. I'm sure they'll arrange with that.
It's the interesting to read it now in context of
We'll find it fascinating. Some things don't read clear. That is, they were tied to visual things. And I'll chat with you if you're interested. We can read it if you find that it's a little hard to follow the demonstration. We have photos of the demonstration, some of it, which I think if you decide that's a any moment, it will be interesting and because Simmons, I know that, it may turn out to be less relevant to your immediate purpose. I think, or they may be relevant enough to spend some more time on it.
I still feel very shadowy. Version of that pajama top than the coast.
Well, the pajama top demonstration.
So
Yeah, I assume that Ray showed you that the one little flaw, I suppose. And I say that because I can't muster a more sarcastic way of describing it, is this total inane theory that Jeff put pajama top over Colette to punch little holes in it so they give hold to the pajama top. Why would you do that? What if you hold it up, stab it to show violent rips, little pricky holes in it? But more importantly, if that's their theory, the trouble is you have to take the pajama top the way it was when they found it. They had no photographs. It was moved all out of place. So they took a photo taken well after it had been moved repeatedly and said, we'll reconstruct it. Then they don't reconstruct that. They create some other configuration and say, well, in any configuration, we will arrange, we'll see if we can arrange it to make all these holes match. And so they stand there for 2 weeks with some barbecue skewers, and they put them through the little holes. They say, look, we can fix this up. We can take this fabric with all these holes. You fold it and you wrap it around and do all these things to it, and we can make it fit. That's terrific. Only problem is this would be a good fit here if it happened this way. If it happened this way, you can see the entry holes on the top and you can see the exit hole here. And you see the entry hole here and the exit hole here. Except they matched up things like this. And, and there isn't any question about it. It says so in the transcript. I said to myself, this is a nightmare. I mean, how does anybody let this evidence in? I mean, they ignore this. That's all. I mean, we just don't pay any attention to it. We got the exits, the entries going wrong. So, on with the show. Uh,
why was the jury
Let's go question. Number one, it was an atrocious jury from the perspective of what we thought a case like this need. Wanted people who would be open-minded, not be snowable. So what the government did is they trotted out hundreds of things. They said, look, we have all these things. And nobody else around. He must have done it. Or he wanted the people of intelligence who reason in their life work, people who are professionals, people who are scientific and technical level, people who manage you have to make decisions based upon data. And we never saw but 2 or 3 jurors like that. It was inconceivable to us. We had done a study of the area from which the jury would be drawn. We knew the demographics of the employment. We knew something about where attitudes were held. I'm not talking about people who believed he was innocent. Why could anyone believe anything? I'm just talking about people who were capable of understanding and coming to us and say, look, I have to be shown. And I understand how to disbelieve things. Again, the manipulation of both the judge and the government. The demographic study we did showed absolutely a very unusually high proportion of people with scientific, technical, managerial backgrounds in the area because of the presence of a couple of things. University, North Carolina State University, several other small universities, a significant element of faculty, administrators. The research triangle, which is a remarkable, industrialization area there involving Raleigh, Chapel Hill, and Durham, employing a lot of scientific professional people. We got the jury list. Showed their occupations, shows significant numbers of people. There were about 3 or 4 people who actually showed up who had any such background. As we would see, oh, here's 1, here's 2, here's 3, here's 4. And every time we would inspect that, someone would say, strike name 17, strike that one. We got done looking at the jury list of 100 summary. About 35 to 40 were stricken before They're called, and they're all of the scientific, technical, and professional people. They're all gone. Now, what this judge had done without consultation with the defense counsel, but with consultation with the government, he said, well, you know, if we send out notices way in advance, they're going to serve on the jury here, they'll all figure out some way to get out of it. So we won't send them a notice they're coming until 10 days before. Now, what happens? 10 days before, what do scientific, technical, professional, other middle income, upper middle income, and upper income people do? They have planned summer vacation. They're going with children. They have paid for vacations and plane tickets. They ain't going anywhere because, except to the courthouse, they're going on vacations. Everybody had been excused by the clerk of the court because when they got the notices, it was too late to rearrange their lives. What you got left over, people were going nowhere, and it was a nowhere jury. There were only a handful of people matched our statistical numerical criterion of being capable of dealing with STEM kids. They were all immediately challenged by them. Every person of education and intelligence was challenged. The university professor of psychology out the window. Judge excused them, threw them out. There were a handful of folks. On the jury itself, there was one woman who had a college degree but hadn't, been involved in any professional activities. She was a homemaker really all of her life. There was a guy with 2 years of air conditioning training at a local community college, which doesn't really represent what we're looking for. And that was it. Otherwise, a very blue-collar oriented jury. And contrived to be that way in the most malicious sense, because for them to have met with the judge and discussed when the jury call should be sent. So the people were told, for instance, in March, you will be called in June, and you're supposed to be there, folks, so that we have a chance at a cross-section community. We got a cross-section. We got fair, picked over, and in essence, a leftover jury. And it was not accident. It was not accident.
I read that you did about the study that you had.
Yeah, sure is there.
Criticized you for this, that this was not reliable.
Yeah, no,
Join us,
yeah, all right. It's I McGinnis. It's also manifest ignorance. Really, never participated with public. Really know what's going on. Doing this. Studies like this are well recognized in the literature. They're discussed in any number of recognized treatises. I have some in my office. Is a extremely important way of escaping the sort of seat of the pants lawyer that goes on. Most lawyers pick juries with the same kind of rules that Clarence Darrow used. Clarence Darrow would say, in criminal cases, don't pick Episcopalians. They have all the vices of Catholics and none of the virtues. That's actually quote from Darrow.
Right.
He says, I prefer left-handed carpenters because they're idiosyncratic and carpenters have this. I prefer Jews because they have a more humanitarian aspect to their lives. Well, all these dictums, some of them have some basis in, you could see some of it. I mean, the business about the Episcopalians, well, maybe, you get wrapped up in kind of very simplistic to the point of full notions. Nonsense. There's all kinds of literature, lawyers writing funny things, not intentionally funny, but funny to read about their theories about what kind of people should be taken. In the 1960s, they began to say to yourself, this is ridiculous. What we really want are people who will come in without preconception. What you're trying to get rid of in jury is people who have already sold you down the river before they hear the evidence because they're not interested in hearing the evidence. Oh, they don't mean to be that way, most of them. But they come in with a life point of view. Their long expressed attitudes on law and order and news and events and public affairs, to the point where they're so wrapped up in the importance of their views or the depth of their opinions, can't hear a case. So what you really do is you're getting rid of people, and you're looking for people who can hold a point of view. It's just ludicrous to think that you pick a favorable jury. Can't. No one knows what's favorable. You haven't heard the evidence. You don't know what the evidence is. You're looking for a way to avoid being done in by people who are overbearing with their own views and will run roughshod over ordinary people who will also wind up getting selected. And in the 1960s, in connection with the Harrisburg Six case, Berrigan brothers and others charged with planning to conspire to blow up the heating ducts at the State Department, make all the bureaucrats cold, and the war in Vietnam somehow. In an effort to try a case in an extremely conservative, middle American community, Harrisburg, Pennsylvania, where no one could even imagine trying successfully ordinary criminal cases, let alone the most notorious criminal case in its era. Began to say there are people who have doubts about why the government does things, and everything the government says is not necessarily the gospel. And with the help of social scientists, began to construct a technique for ascertaining something about attitude and constructing a model of where attitudes lie. And you're talking in very general terms. That was the beginning of scientific jury selection, scientific jury research. I was involved in it, followed it, done the work for other lawyers, done it for my own cases, and in this case, put together a team that did it. The only trouble is we had a profile that couldn't be met. There was only the only juror, by the way, in the case who met the profile was the 13th juror, the alternate, who said after the trial, if I recall correctly, if I had been that jury, they'd be still sitting out there. There's no way I would have convicted that man. He was the only person that met our profile. So, I mean, of course, Joe McGinnis never spoke to me about the jury study, didn't speak to anybody else involved. You must know that Joe McGinnis spoke to me only one time, really, about the case. And that was after writing the book, going around the country on a little publicity tour for something, came to San Francisco and wanted to ask me about such things and how I got into the case. That was it. That was the meeting at the Mark Hopkins Hotel, the infamous meeting where Joe's idea of having spent 2.5 hours of my time listening to his nonsense and then, avoiding the question about letting me see the manuscript and then expecting me to pay for his drinks. So Joey Morris to pay for him. It was part of his penurious attitude that didn't endear to us. Sarah and I, both present.
In other words, you had that study, but you were not able to act on it because
Absolutely. Because the
empty.
pool had been emptied. Exactly.
Okay.
Said better than I would say. The pool had been emptied. All the fish that should have been there had been sent off on vacations.
So it isn't that you picked the wrong jurors, but you had opportunity that you, I mean, the way it was affected in the business of that was that you just, because of your study, picked people you wouldn't have picked if you would not have had your study.
Well, no, we try to use we only found one juror. I'm absolutely positive about this. Who matched it works out the numerical scale. You credit various qualities based upon your survey of the community. We did something like 600 telephone calls, very carefully, statistically sampled the community. Within the calls, different age groups of people were called. On the first call, you talked to the oldest male registered voter in the House. The second call, the oldest female registered voter. Third call, the youngest registered voter, the male. Next one, the female. There are all kinds of structures that are built in to get a real cross-section sample. We knew who we thought had the potential to being there. Sure, picked the wrong jury. Only 4 of them, believed at the end of the case was not proven against Jeff, and they didn't. And the 8, ex-Green Beret, ex-cop, some really strange people, said to the 4. This is, I recall, the interviews that were done after the trial, and they appeared in the Wally papers. Because other reporters interviewed the jurors, and they asked the minority jurors what was said. Well, they said, "Tell us why you wouldn't kill his family." And they didn't know what to say. And the majority said if they had given us one reason, we would have voted with them. What in the name of hell are we talking about? The case is where is the evidence beyond a reasonable doubt that he did this? And the burden is on them. This went berserk. The jurors came in, the 4 were weeping and tears came. They surrendered, but they know how to answer each other. They're very ordinary folk in a very extraordinary case.
But you seem to be suggesting that you didn't let you pick the wrong. You had picked.
I did pick the wrong one because I should have picked some others because
the others would have probably been just as wrong. The good ones.
Well, I suppose. Yeah, I think that's the conclusion. Yeah, sure. Now that we're looking back, gee, the things that we thought might be good about this person being what was left of the fish in the pool really weren't right. They were certainly right about four. They weren't strong.
You know, just like in the civil suit, nobody knew about the fields in it.
Oh God, yes. But, oh God, can you believe this? Talking about animal rights in jury room. Pam Fletch was in the jury. Yeah, he was. No, it's a local joke we have or something like falls about the same category. Stu, who would make that kind of lunatic through a juror.
Well, I very much myself for animal rights. So
Yeah,
that's
absolutely.
the issue.
Well, no, it was a kind of what an
She
attack.
alienated the others, or I think the problem was twofold. One was that she had, and I've spoken with her, which is that after the trial, that she had already made up her mind before nothing was going to change.
Right.
Yeah. And second of all, she decided the other people were laughing at her and was laughing at her.
That's because she, as her irrelevant subject, she got involved in talking with jurors. I gathered about the animal rights issues in the middle of the trial, which was sufficiently fascinating.
Yeah.
And she constantly was preoccupied. I always, I'm a dog lover myself, but no, it was the inappropriateness of the things she was doing that sort of, oh my God.
But nobody would have objected to her because she was not a crazy person, right? But I was the
But yeah, because they were laughing at her, she got her back up. Said, wait a minute, what happened to the attempt to discuss it? What's the juror's function? It all broke down.
Yeah. Yeah. So there's no way really.
No, I mean, look, you have to say, I obviously was wrong. Why? Because the result. Were there better there? Not by any objective scales that we had. I mean, there weren't people who I affirmatively wanted, who I didn't choose. There were other people who were equally within the range of people outside my areas of interest, my feeling that they were open. And it would have been substituting one for another. Maybe I would have done better with the other. I can't tell you that, and no one else can. To say that we did not do the most scientific, most careful analysis of the problem is wrong. To even impute that we didn't do, use the best wisdom known, best techniques known, people that I believe to be as able as any around in this area, all subject to the limitations of a strangling budget to try and do any of this stuff. And that the fact we didn't get the right result. Well, why didn't you get the right result? That's the answer. And there is no more I can say. I wish I had picked 12 others. I'll tell you that.
So the idea seems to be that the idea there be some scientific way of deciding the budget. But you still believe that the good one it goes out.
The jury's scientific jury, sure, and it is particularly so in a notable case. Ordinary cases, there's not enough there. We were probing, for instance, how many people had already developed a fixed attitude to the community based upon this information. We never ask individual. When we call people, you don't know their names, you don't ask their names, you don't keep the record of their names. Because you're really only interested in the demographic groupings of people, because your analysis comes out demographically. Males 20 to 27 working in clerical jobs and who have a 8th grade education are more likely to feel this than males with, you have all these scaling factors. And it is work with some.
So the idea is that you ask questions in the community that you wouldn't be permitted to ask when interviewing.
A lot of time, that's right.
And then especially.
Yes. We did get some profile information, jury. The judge, I should give the judge credit. He allowed credit. Give it with one hand and take it away with two. He did allow us to use a questionnaire to speed up the jury selection process, which he took over himself, to not allow the lawyers to ask the questions. So we propose, well, Judge, let's at least get the statistical data on people, stuff instead of you asking all these dumb questions. Why don't we have to do it? So we did a questionnaire as the government added a few questions. So we had a fair amount of the demographic data for everybody. The trouble is, it didn't make any difference because the pool had been picked clean of the live fish. If I had to do it again, I would most assuredly. No one could believe trying a major, major hit without some attempt to do more than sort of sit there and by the gut of your pants. And I think she looks at that woman's looking at me like I might be her son. Let's keep her because she will see a mother-son relationship and find me credible. I like that fellow over there because I can see that he's a sports fan and not this cockamamie folklore that lawyers rely upon. As I said, the Darrow things, but one of the truly great lawyers of all time in America, is still, is laughable in terms of giving it much credence. It is sort of a gut reaction to what you really strive for. It's a chance to talk to jurors. If you were given a chance to conduct a flawed view, damn it, George, you would be very excited. But I could learn about people that ask questions in a meaningful way. How forceful are they? How canthorough? A very standard question to ask people, do you think that because the defendant has been arrested, charged with this crime, that he must necessarily have done something wrong, otherwise he wouldn't have been arrested and charged? Everybody knows the defendant is supposed to be presumed innocent. So in the statistical polling business, everyone calls this a phenomena of the predictable response. Everybody says, oh no. And I say, oh shit. What do you think the police are, morons? They go around arresting people for no reason. Oh, there are small genre of cases, political and otherwise, with the wrong, treatment by the police and wrongly arrested. But that's a small genre of case. Basically, the police only arrest the obviously guilty. That's why men sitting in office buildings, writing on pieces of paper, ripping the environment to pieces, stealing millions of dollars, fucking over society, don't get arrested. It goes to a police officer that doesn't look like an obvious crime. But when you come to murder, you arrest people because there's obviously something there. And for the prospective juror who doesn't say that, so you say, you need to say, you think the police arrest someone for that good reason? Oh, no. Well, tell me. Well, don't you think the defendant probably did something, otherwise he wouldn't be here? Now, I don't really care the person expresses the belief that the defendant is probably guilty. What I'm looking for is a person, first of all, reason to drop the pretense of the phenomena of the predictable response and talk candidly. Say, that's good. Now that you said that, I appreciate that. Listening to your gut instincts, this person is fake. I would walk across the street on that representation. I think this person is very good. I believe this person is honest, And I can recall a case that I did in which the judge asked the particular respective jury, said, now, is there any other reason, after all these questions were asked, best known to yourself, why you might be prejudiced against the defendant? He says, yeah, it's the defendant's lawyer. I would hold it against the defendant. He had a lawyer that looked like that. Well, there was general hilarity at my expense, and not so everyone thinking they're having a good time at my expense. My partner then got up and said, Your Honor, the respective juror said, it's the defense lawyer. I want the record to show that he was pointing at Mr. Segal and not me. There's more hilarity at my expense. At which point the prospective juror says, yeah, it says to my partner, but you're not so hot either. At which point the lunatic defendant got up and said, I like him. I want him. And I said, I like you too. You're honest. I appreciate it. Will you try and do your best not to hold it against him? He says, all right. It was terrific. It was terrific. He was a wonderful man. He absolutely, I loved somebody who could come right out. So, yeah, you're not my cup of tea. My mother said the same thing. I said, my mother said the same thing. She said like that a little bit. My hair went long.
What is your overview of the civil trial?
Well, thought the civil trial got a bit out of hand. An awful lot of evidence went in, particularly get asylum. It's hard justified, psychological stuff. But I think it was comporting with Judge Ray's feeling that he would rather err in the side of giving McGinnis a fair shot at the way he tried very hard to make sure that McGinnis didn't get an unfair shot at Jeff. He attempted to balance them. That's optimally what a judge should do. 3 different judges can try the same case. Each will try it differently. One will let in everything, the other will let in very little that isn't absolutely required, and the middle judge is sort of a compromise. And all 3 trials could be upheld on appeal if on balance, the ebb and flow of fairness and unfairness and the ultimate effect, the mix that comes out, he's okay. He did a very job. I thought the overview was unconscionable. It should last 6 weeks. And I couldn't believe it lasted that long. But the trial, the numbers that were settled for were numbers that Sara and I had both concluded were about the right range for settlement. We told Jeff was in communication with us and Gary of what the early pre-trial settlement numbers were. He said, absolutely not. Do not settle for this. Sara, the Assurance Defense Force really has a good understanding about the tactics here. And she's saying to me, says, right, Jeff, tell them they've got more here. They're holding out. They're trying to bleed you. This is your target. You got to understand when you probably are never going to settle for better than this. The numbers came out exactly right. We were remarkably on target that case.
So you would have predicted there would be that settlement. You didn't think it would go to affect the trial.
No, I absolutely, after the trial was over, and again, I do rely a lot on Sara's judgment. This really is her expertise. It's a question of the evaluation that had to be done by Kornstein for the insurance company. You had to go back to that, say, this is what happened, including the post-trial interview of the jurors, particularly because those interviews were also pressed so that other people knew about them. And a 5-to-1 leaning for the plaintiff. And the insurance company having spent a huge amount of money. I mean, to have Kornstein for 6 weeks in Los Angeles, plus the enormous amount of pre-trial work, it's all fancy. Yeah, they pay for his hotels and food. I mean, the logistics all day long is billable. All weekend long is billable. Yeah. It's very, very severe. Yeah. And now the insurance company's been told that the jury, no matter, despite all of these efforts to, smear Jeff, murderer, had 5-to-1 in favor. It's a question of where the numbers are going to fall. Because, hey, we're not going to invest in another, at least $250,000 trial. And take a lumping, maybe we'll be, now the defense has seen the plaintiff seen everything. So it was clear to both Sara and myself, and certainly to Gary knew that. Although he was more cautious, he didn't want to get Jeff's hopes up. But I think none of us really thought any right-thinking insurance company going to risk another $250,000 and a bigger verdict, and they could settle for about this area of numbers.
Yeah. That's the point of beginning of the defense in that trial. There was too much time spent on the prosecution or the plaintiff.
Well, I thought Gary was very efficient in his examination, that the cross-examination, we should not have gone as long as it did. In my instance, I was on a day and a half, less than a day and a half for direct, and I was cross-examined for a day and a half, of which an awful lot of it was me being allowed to give my opinion on a great many subjects, which was not to their benefit. They didn't need that from me. The trial could have been shorter. It was part of my critique that I don't think that that's the way to handle it. I don't think many lawyers would agree that was really well tried with defense. But I don't mean to say for a minute that the verdict was a function just of the skill of Kornstein or my disagreement with his practice of Kornstein. I think that the jury, in spite of the way it was tried, saw the merits and the demerits in the case. What you risk as a lawyer when you don't try it well, the jury loses sight of what the case really is about, where the real issues are, and how to decide it. They get so muddled. They get so buried in an avalanche of words and misconceptions about what it's all about. They can't come to correct resolution of some sort. Here, the jury didn't lose it. But it was not to the defense's interest to confuse the issue in the trial. They could run their First Amendment theory by, but they certainly wasted an awful lot of time trying to attack the witnesses that Jeff called. And they were much more efficient, narrower attacks, There are areas of vulnerability that people had, or at least theoretically from the defense standpoint, those should be considered vulnerable areas. They should have gone with them. And the trial could have been done in about 4 weeks.
Yeah. Well, it's possible that another judge would have not, first of all, let it go so long or that many areas, uh, Lord, and also another judge would not have um, ignored or just chosen not to let them count those petitions in New York. They think that it's
Well,
sort of
okay, apropos of that, number one, I truly believe in the example that 3 different judges tried the same case in considerably different styles. What evidence is admitted, what is kept out.
Yeah.
Judge Ray opted for the style that said, it's hard to fault the judge who gives a party that may lose every opportunity to win. You can fault a party can fault, like McDonald attempted to fault the government in his criminal appeal. They never give him the chance to win. Cut the legs off of his table. Judge Ray took the view, look, I'll let the parties try the case. Yes, it's a little longer. Going to take a little more time, but 2 weeks more now maybe means that the same as a 6-week trial later on and an appeal later on, that the party knows it had its day in court. That's what Jeff McDonald never had in his criminal case. And I think it was a wise decision in a case where it's a difficult case, difficult legal issues involved, to say at least let the parties get all the facts in. Maybe the guidance of the jury that if you're allowed to tell your best story, Jen, you, Joe McGinnis, can tell everything you can about your case, and that the jury believes one side or the other, it'll be guidance to the parties, to Senate. That if you get past the legal issues and you have to try the facts, and you got all the facts in that you thought could help you, and you still couldn't persuade a jury, maybe you better settle and get out of it. And so I think from that standpoint, there is wisdom to it.
Mm-hmm. Mm-hmm. Yeah. But another judge could also have agreed with some of the others, like the insurance company judge and that magistrate, like they had, I understand, the idea that the word libel suit and therefore,
That will remain disputed for a long time. Until an appellate court decided uh, it was. I disagree with that. That's a simplistic point of view, but as I said, others take a different point of view. I think it was properly brought in the contract suit.
well, this was certainly a great decision for
Sure.
us to go forward.
Well, I would say that Kornstein and the insurance company's confidence in their position wasn't so great. They were willing to invest in it again.
Right.
So the second trial, they could have done the second trial more efficient. Each side has thoroughly revealed its whole case and everything. Now there are a lot of questions they wouldn't ask me if I came back a second time. They would have been much better at it, and they would have done a shorter trial, and then they could have saved money, and then they could go on appeal, and they were very confident. Wouldn't have cost them all that much to do it, and they would have walked away scot-free. They weren't that confident.
Yeah. Yeah. Certainly I think once the they filed that if there was a moral position that problematic for it in front of the jury. We're reading those letters out loud in
Yes.
court.
I just don't think they really perceived how badly ordinary people would look at them for that.
Yeah.
That there was this smugness that I perceived, the arrogance that I characterized, that did them in. They just couldn't perceive that everybody wasn't as enthusiastic about saying the First Amendment. Jurors have a much more rudimentary sense of fairness. One has to only look at Pennzoil versus Texaco, see what people think about unfair dealings, sneaky dealings. Plus $10 billion. We're going to settle for $3 billion, but that's not chicken feed. And there was no respect for that position. No insight or understanding. The case could have been settled way before. Joe McGinnis had nothing to say about it. Joe McGinnis stood in the way. The insurance company would have said there's a cooperation clause in the insurance policy. And it says if the party that's covered by insurance or protected by insurance fails to cooperate with the insurer, the insurance policy is vitiated. We're not responsible for then depending. We don't pay you, judge. So McGinnis didn't control the lawsuit. There was talk about, well, Joe wouldn't allow this, Joe wouldn't allow this. Bull. Insurance company tells him that, hey, premiums paid by somebody else. You have covered. And we need your cooperation. We want you to get McDonald's willing to settle this. We want the transcripts. And we want to get out of this case. It's enough blood on the floor. Let's have that. I want to hear about your principles, this thing. There's a lot more leverage than,
Yeah.
and for the insurance company, a lot less for Joe than for let off.
So that makes sense. Yeah. And then they wouldn't let it be known that the insurance company would pay.
Oh, that, of course, is such a scam. That's so Joe can mislead people with thinking, poor writer had to pay.
Oh, no. It was said that he didn't pay it.
Yes.
But that somebody else did, but they wouldn't say who it was.
Right. Well, the implication was, though, that he was personally affected by the judgment. That's the way I read it. I read the L.A. Times. I thought that, what a strange way to do it. As if, why would Joe want it? He wants it for some public relations.
Did he want it, or did the insurance company not board to invite further lawsuits?
Oh, maybe. Could be. I may be miscrediting.
I was trying to get some information from Sturgeon, and he just said, cancel.
Yeah. That's it. Okay.
Yeah. So again, one of the subjects that remained from suggestion. But I guess the question that sort of somebody like say Floyd Abrams would ask about this would be in unattractive behavior. We all agree that the way it behaves was not attractive, because is that actually good? That's after all.
Well, that's putting the rabbit in the hat and then pulling a rabbit out. If you say, gee, I'm going to call it unattractive behavior. Look, what we have here is unattractive behavior. No, unattractive behavior is probably not actionable. Shouldn't be. The world's full of a lot of unattractive behavior. We don't need more litigation. It wasn't unattractive behavior. This unique case. How many contracts are going to have a clause like I put it? How many writers and how many publishers are sufficiently greedy that they will willing to do this? How many other subjects will have learned from my sad experience in this case? And maybe the best you can settle for is demand in writing to get the manuscript a full 30 days before it gets set and typed. I don't think there'll be another case quite like it. Certainly, we're unique. Why I think it was properly resolved this way. An appellate decision in this case would not necessarily be very helpful to a lot of other cases because of the one-of-kind fact situation.
Yeah.
But on the other hand, it certainly should teach, the writers and publishers the same thing that the Pennzoil Texaco case did. Same thing that Pennzoil Texaco case taught the business world. The same way no one could believe that that Texaco would be held liable for running in and interfering with the attempt by Pennzoil to buy Getty Oil, and they step in and Texaco buys Getty Oil. That's just business. That's the way we do business. Good, hard, aggressive business. That's what they say. Everyone says, sure, good, hard, aggressive business. Jury said, the hell with you people. You asked us what we thought. We think that is the pits. They hit it with the most astronomical judgment. Just, wound up in a $3 billion settlement. Same thing here. There's a lesson in this case. I don't care. The point of law is uniquely to itself. Of the facts of this case is unique. I do think it does send a message. And if it doesn't, they ought to beware.
Yeah.
They ought to beware. They're in trouble. They're a real mess. No? Okay.
Well, this is what is it? I think with just one case, it's sort of totally bizarre and isolated.
Not worthy of all this effort. I would agree.
It's just some sort of a grubby little fight about money or about sexual circumstances. I mean, there are some sexual circumstances.
Sure. The overall principles raised by the case. I think the case raises principles. I don't know what the principle. I don't know the point of law, how it might be resolved in appeal, but it's less important, I think, on the point of law and more on the question of the profession's principles as far as the writers are concerned, jury perceptions about fairness. How could you imagine? Or worse, a plaintiff, guy convicted of triple murder, being able to come in and persuade jurors. That tells you people had to be deeply affected by what they had to consider egregious behavior.
Yeah. Yes. Yeah.
It's not nice to be found to be wanting that way. It means we have to re-examine our conduct. The way business is going to re-examine its conduct before anybody runs in and somebody else has got a contract and just sort of stampede over them because you're bigger. Not do that so well. And we're better off for it. Regardless of the principal law, as a practice, a way of living in life, we're a little better for the litigation there. And I think maybe there'll be something a little better in terms of some of the relationship between writers and subjects.
Yeah. Well, from explanation.
Okay, good. I didn't finish one thing I thought of. I had an envelope finishing is the incomplete answer you were asking about earlier about Saab that I think that Freddie Saab caused the investigation that came before, and I went into the life of its own theory, the glory, the no-lose glory the prosecutors could get. And yes, Freddie his role was provided a catalyst for it. He provided the tweaking public attention to it. There's sort of his quixotic fight, with this one little guy going around doing this, and that modest amount of attention, the publicity factor, made the other factors fall into place. Great unsolved mystery, the case that has a life of its own, and that made it happen. He was merely the grease. He certainly was not the cause of it. It was a sort of extraordinary set of circumstances. The petition that he filed originally in court in North Carolina was without any merit. There is no grounds for a federal court to order a federal prosecutor to investigate a crime, or the FBI investigating crime. The judge did not have jurisdiction to order such matters. And ordinarily, a judge would say, take it away. If he or she's kind, I'm sorry about it, but take it away. Go down and see the prosecutor. The judge was not too pretty. Just sort of said, well, we'll refer this, we'll send it over to the U.S. Attorney's Office and ask them to look into this. And instead of just tossing it out, the garbage heap of the law, he kept it alive. And that generated a little bit more publicity, all these 1.5-inch stories that were running around over those things. And it wound up in the U.S. Attorney's Office. Somebody said, well, what's this all about? Then Murtaugh said, oh, piquing interest here. And, and all of a sudden, the great monster of the case begins to breathe again, and the idea, maybe we can really get something going. And then there's Warheidi, fortuitously at the end of his career, looking for something to do because he got nothing to do. He's phasing out. And somebody said, well, we'll give it to them to look at it. That's fine. So that's Freddie's contribution to it.
Yeah. I guess catalyst.
Sure. He is the little bit of grease that pushed him on, but he didn't do it. So then, in our sense, we were, had also confronted the government because I had been writing to them saying, hey, it's not right to be just hanging here by our thumbs, twisting in the breeze while you sit on this case. We've had it since 1972. I used to write every 6 months. So 9 months apart. We're not asking you to go ahead and prosecute us. If you've got something, let's do it. Let's decide. If you need some more information, like us coming down to talk, we're willing to come down. Suppose we said nothing, maybe somebody would have let us sleep a bit longer. I don't believe that, but I think that's a theory one I have. But that's me. I wanted to sort of finish up the story. That's it.
Yeah. One Only question I had: were you aware of those tape recordings being done
By Freddie.
by McDonald in prison?
Oh,
that then
they sort of as an afterthought, Jeff told me, they were already going on and said, oh, by the way, Joe was asking to tell certain things. And that's how I found out about it. This all happened while we're in the midst of now writing the first of a series of massive appellate briefs. I mean, appellate brief is 300 pages long, talking about a genuinely high quality magnum opus here. It was a beautiful piece of work. We had this man's disastrous trial to resurrect, and Joe McGinnis is sending him tapes. I don't know. Okay, sweet. He already started to answer the tapes. No, I was not. No, Jeff.
Interesting to me there. One of the reason for the taping was that they wouldn't allow him to take notes or bring a tape recorder and say, Kevin Lyle. No, I eventually couldn't there. There's a tape recorder. Jeff doesn't know why that.
The policy varies depending upon the phase of the moment.
Okay.
When you deal with it, my colleagues are very
got a blue suit on. Sorry, today's crowd.
Both Bill and Craig know the struggles we have had with the Bureau of Prisons. I cannot to certain prisons send packages by Federal Express. I may use only express mail. Horribly. Why? Because.
Haha.
It's hilarious.
Yeah.
Can't bring a tape recorder. Why? What is he going to do? He can write it to me, can he? He can tell it to me. You can't tape him. Then other times, you call, you ask, and tell him. There is no problem. It's just the irrationality, the mind-boggling irrationality of prison administration. Can't tell. And I don't know if it's even true or not, when they said they couldn't do it then. It is a frequent rule, though, that we can't bring tape recorders to this institution. This is most times I'm not really in need of it. I prefer to make my own notes because it requires me to ingest the material more carefully, do my own follow-up. It's rare that I would want, but there are the jails, federal jails, that you bring it around with much trouble.
I think Jack's really the very range for communication, hour long or 12 monologue. Very difficult. But I also was puzzled as to why, but I was prison for 18 months. He continued, they taped instead of talking.
Well, did you talk to Jeff about that?
Yeah, I did, and he's very trouble. It's somehow they had gotten into this strange rhythm.
Right. Well, again, it was, to me, it was reflective of the Jeff McDonald commit the idea to tell everybody the whole stuff, warts and all. It would be good. Sitting down to written this out would be a monstrous task of Jeff.
No, they could talk. McGinnis could come out and he said, "Fuck."
McGinnis begged off that. I know he did a lot of things.
He wanted to distance it.
I think there's something to that. I think that was a way of avoiding Jeff. Avoiding.
But if they weren't to come up fully, I do there, creatively tape.
Oh, I think McGinnis was essentially lazy. That he did not want to travel that time. Travel well. California, sit there, hard times, talking. He would have required a half a dozen trips, several days in length. He would have had to pay for that out of his pocket. His penuriousness, I think, is absolutely an issue. He is a cheap son of a bitch. I mean, and appallingly so. Sarah wasn't kidding that we are being asked to pay for his dirty laundry. I mean, that's it. I mean, unbelievable thing. Never chipped in a dime for the cost of the meals that we all ate. We had a collective kitchen. We hired a cook and everything. I mean, just not even asked. Maybe wasn't. He probably said, "No, it's all right, Joe. We'll just absorb it." But it would have been the adult thing, the menschlich thing, if you will. It totally escapes him. It is that kind of commitment to other people that he doesn't show. hey, I have to be sensitive about their side of this thing too. And I really think that the cheapness in the man probably is as good a reason. Plus, I do think that, this kind of distancing was going on because, I think he could confront Jeff. Having to see Jeff, I think Jeff would ask, Joe, how's it going? What's your staff? What's going on? He would have had to answer questions himself, because I think he was unwilling to do it.
And you was already contacted for himself, so the right.
I had only 2 or 3 contacts with Joe McGinnis after the trial. To do him favors, to head off the competing books. Oh, Bernie.
Oh, that first started.
Right.
Right, yeah.
Oh, and a telephone call to me, but most of it was Jeff. He would, Jeff, you get Bernie to do it. Bernie won't really listen to me. So he was distant, he's very distant from me. His explanations about why he never talked to me about the issues in the case. For instance, he was asked, well, why did, this theory about the amphetamines? It was a memorandum of Bernie Segal, of which there was one copy in my file, one copy in Jeff's house. Why didn't you ask Bernie about that? Oh, well, Bernie believes in Jeff. Jeff is the consummate liar. Jeff would have lied. Bernie would have believed him. So why should I ask him? I beg your pardon. Yes. Really? Didn't know why I got reduced to such idiot level. Transparent. Because he knew that if he was confronted with it, it would have raised more suspicions. He would have had a difficulty sustaining, writing it, without when he'd been confronted with facts that he deliberately avoided knowing about. Seemed to me extraordinary. So the only time we talk, a couple of telephone calls relating to won't I get after Freddie and the others who are trying to write competing books. It won't be worth anything, and Jeff will be hurt by this thing. It's really all for Jeff, and got to stop Freddie from doing this thing. And then the one time he came out here and on a trip for promoting another book and talk only about how I got into the case.
So it was that leading it at the
Mark Hopkins.
that's when you began to have this.
Oh, yeah, I asked her right away, yes. When are we going to see the manager? How was the book? Sarah, asked him, how was the book? Well, very vague, very evasive. I have a bad feeling. Says, I haven't told you. It's that bad. That might work with Jen. Don't fucking. I'm happy on this. Well, that's all you need from me. Feel free to talk. Call me again.
I'm sure I will.
Glad Sarah obligated. I suppose to
There's
We
covered
talk
a lot of ground today, but I'm sure that there will always be more section,
yeah,
especially after I read that transcripts.
oh, absolutely.
Really
Absolutely.
made me watching.
I suppose it's out of a sense of frustration that you feel for Jeff. That we talk about because there was no other way to get it out of our system. How much pain involved for all of us. To see where he is, his situation is. It's not very directly helpful to him, but it's probably helpful. It's probably therapeutic to the rest of us. Talk about it.
So I suppose it's the theory that the McGinnis book legally poisoned the atmosphere and made it the possible something to do was for some way influencing the feel. Conversely, obviously it's written with that Christ raised the question for it is exactly.
Yes, I think that's true.
Imagine that's the motive of everybody and talking to other people and doing and everybody else considering the possibility that anything.
Well, I guess from my standpoint, I feel a deep sense of frustration about the situation and deep sense of violation by the way McGinnis dealt with this. Wish that we had been more cynical, hard about it, ruthless, I suppose. regard to than the book situation. Just, obviously, those of us who know Jeff, and who have come to the opinion that he is wrong, do want to help. I have to say this about my feelings about the case. My own sense of self-worth, my own ego, do not turn on the fact that my client is guilty or innocent. Yes, challenge the case. I tried the case. I put the government to its test because what the law says, and I'm doing is extremely well. That's my fun in life.
Yeah.
That is what I like to do. It is not a personal matter that, gee, client is still claims you feel bad. No, I'm not protecting just the client. I'm protecting the system. Jeff could be, in fact, guilty. I could believe his guilt. It would not change my feelings. So a man who is convicted in a ruthless, unfair trial is a man wrongfully convicted. Because the system is violent. This everyone is less safe. Of course it is. But having said that, much as anybody who was not there on February the 17th of 1970 will ever know, I know they did to him. I believe that not because I need it for me. I believe it because I would be lying to myself. Otherwise, I would much prefer, in a psychological sense, to represent the guilty client. Because despite your best efforts, if you lose a case, one of the small consolations you deal with internally is the fact the client has to consider being convicted as part of the cost of his or her doing business. Because when someone in a drug case, in a white-collar crime, gets somebody in a robbery, hey, get convicted once in a while for your bad deed. That's just part of your life. You arranged your life that way. That's not what's happening here. To have gone through all this, I would assume at the beginning when I heard the case, I would assume he's guilty. They wouldn't have charged him with guilty. To realize and be slowly educated, slowly uncover, the reality is, my God, what a total farce this is, what a total mistake this is. It's very bad. It is terrible. I have often been sort of kiddingly thought of putting a sign over my door, only the guilty shall enter here. Much easier on my stomach. Keeps the acid from generating that way. But it's why that it's worthwhile talking about it to him once in a while, not too long. To sort of deal with a sense of frustration and futility once he feels poor Jeff in their situation.
Have struck with your remarks that people who commit crimes once in a while have to taste a little.
Sure.
That once in a while. You don't feel that they always should.
Oh, no. They might steal. A fellow might steal half a dozen cars and sell them to a car theft ring. May only get caught once, and if he gets caught, convicted, he has to realize that's the price of his doing business. He's chosen that. And as a lawyer, you might try it well. The evidence might be inadequate for the government, and you still lose it. You say to yourself, I shouldn't have lost that case because on the basis of the evidence and the proofs, I should have won. But I don't feel personally badly about it because the client objectively was guilty.
Right. I would think that that's why one would be comfortable always having people you feel are guilty.
Yes,
because
of
if
course.
you lose, you could say, well, morally, this is a good thing
Well,
to happen.
no, I won't say it morally because the moral questions are more complicated than that. What I'm really saying is that in terms of how you live with the disappointments of your own work, that it's less good. One of the things is, well, thank God, although I may not have been as great as I would have liked to have been today, or been absolutely as miraculous or wonderful as I would hope to be, it isn't so hard to accept the failure because the defendant really had to expect at some point in his life he's going to pay a price for what he's doing. That he's going to occasionally be convicted for crime. I mean, I don't mean that he should be ever acquitted, but I'm saying that if he steals 6 cars and he wasn't arrested 5 times, the 6th time he gets arrested, convicted, that's not a shock to him.
So what if you could send somebody who has committed a brutal murder and you feel convinced yourself that he did it, the way you feel convinced that O'Donnell didn't do it, and because brilliant as a lawyer, he could quit it. Do you have any problem with that?
No, I don't for this reason. The higher purpose that we're serving, I genuinely mean this, is the protection of everybody. Protection of everybody is really not to be had in one policeman arresting one murder suspect. Protection of everybody is a system that protects all of us against those with power. They are the greater danger to the largest majority of people. There are only a finite number of robbers. There's an infinite amount of governmental power in our society. To the extent that it is not regularly kept in check by a system which guarantees anybody who's dragged into it will get a fair trial and fully protected. To the extent that's not there, then we're all in danger. When you take the worst case, which you say some person has committed heinous murder, that I objectively believe he or she is guilty, my own personal consolation is that I did a very good job, but I'm not just bragging to myself. I am satisfied the system worked because if I succeeded, it is because within the rules that we've agreed to, they could not prove the case. That is a miracle for all of us, and that's good for everybody. And I don't have any doubt that that's one of the most important things that used to distinguish our country from a lot of other societies. There's a legal system to protect. These days I'm worried about. I don't really believe we're doing as much to. We have eroded in the name of the last 8 years of the Reagan administration. We have done heinous things in the system. We're less well protected than we have ever been. And it's even more important to defend people and not worry about objective guilt in certain instances, but to be satisfied that you have really made the system work creakingly, slowly, painfully, inadequately, but you made it work. Everybody's a little safer, and I feel like I've done what I really need to do in this life. I feel that very, very passionately.
I have a question. Sarah said something. How could you just happen? Given how you feel, given the way you perceive the system, how could you not just say, oh, yes? And pardon my choice of words, I'm not as eloquent a question asker as you. How could you not just say the system doesn't work because this guy is innocent? Of all the guilty people I've defended, this guy's innocent. How could I not do it?
Because what you have to recognize is that we've created a system which has as its goal achieving of justice. And the way you measure it is not every case is justice, because it's impossible. The way you measure it is to say, how close do we come today, this month, this year, to having a fair amount of justice in all of our cases? Gee, we did pretty bad this year. We did a lot of things in the legal system that undermine justice. We're not getting very close to it. What does that mean to me? I've got to work harder. I've got to do more. I've got to turn more people off. We need to get out there. We can't give in now because it'll be like an avalanche on us. What dismays me are those people who try to do this kind of work for a few years. Oh, I'm burned out. Burned out? You haven't even begun to fight. What do you know about burnout? The battle to make sure that we're all secure and safe for the legal system to protect us goes on all the time. The conviction of Jeff McDonald made me worry more about the safety of everybody from being oppressed by a government that could spend ultimately $10 million to vindicate a bureaucratic nightmare. We were right when we arrested him originally, and the judge was wrong then, and we're going to go out and do whatever it is to destroy him so that we're right. This is the Dreyfus, theme that occurs here. So I have to work harder and do more. That's what keeps you alive and going. Shame on all those people think, oh, I didn't get a good result today. I don't like that. The system's no good. I give up. The system's run by people. It's the best we've got around here. You could have some other system, but they're not any more perfect at achieving goals. But they are better if we, were involved in it. Say we have to get down harder. We have to hunker down. We've got to really put the shoulders to the wheel where everybody is more threatened than ever. Really get into this. Give the speech, but that's something of great importance to me. Why I teach.
Jeff told me that he did in prison, because it's kind of during the Reagan, I guess he sort of takes prisoners. Reagan kept his office. He has watched the population of double in the federal system. And so does this fine. That's the favorite difference.
We are filling up and overflowing, really, all prisons. We are largely filling up with drug cases. Not that we're putting more bank robbers, more rapists and robbers in federal prisons. Because that's what how big risks for that mill robbers are, of course. Filling with drug cases. Not with heroin dealers, marijuana smugglers, cocaine transporters. And they will, jam them in, even jam them, and we will, due course, jailhouse explosions. Attica will have its progeny one of these days.
Yeah.
And all of America will say, gee, why did that happen? Why? It's one, I kind of think, you told me a story about the fellow in the cage. One prisoner said, take somebody, put him in a cage, and then jab sticks at him through the bars of the cage all day long, year in and year out. And then you let him out and you say, gee, how come he isn't any better? Try it sometimes. Try it. You won't like it. That's, and that's going to produce an explosion. And then we'll suddenly wake up again and we'll go through the soul toll trauma, what we're doing to people. Well, why are the jails so crowded? Why are there being caged like this? Well, we have all these dope people. Why the hell are the dope people there? Why are the sentences now skyrocketing for those kind of things? Let's get them the hell out sooner. That's not what we want. We know what we need jails for. We need really people to scare the rest of us all the time. I don't mean to free the dope dealers for nothing and anything else. I don't mean to approve of that. I'm saying we have gone insane. We are giving people, drug case after drug case, 10-year minimum sentence. You must serve 8 years and 2 months. There is no other federal crime almost. If you commit, you'd have to be a multiple bank robber to get a sentence where you effectively serve that time. I'm not praising or approving the drug dealer, I'm saying, but hey, the rest of the world, the rest of the civilized Western world, has managed to scale these things in proportion. We give the third longest sentences of any Western nation in the world. Who gives longer? The Soviet Union and South Africa and then the United States. What terrific company we're in.
Yeah.
Look who we have picked the role model. And the soapboxes. God, times. I'm Lord. I have no idea.
Car's not locked in.
No, that's
It doesn't look like it.
No, you thank you. Cars locked in the garage a few times. The garage building closes where I park my car.
Oh.
If I don't think we go before 8 o'clock in the evening, to show you when things go wrong sometimes, they really go wrong. One night I totally forgot. I was very, very late. I was getting ready to go on a Disney trip, but just not too long ago. I arrived at the garage. Oh, God, the car is locked. Oh, they changed the hours. I didn't even know the car locked. Oh, God. So I have to get a taxi. I go quite a distance across the Golden Gate Bridge in town. I live up an extremely steep hill. So when I call the cab, it's 2 o'clock in the morning. I said, I want a cab. Don't forget, it has to go up a very, very steep hill. No problem. Cab driver picks me. We go over the Golden Gate Bridge. We go up the hill. We start on the hill. It was 1 mile up the hill, beginning of the road. Cab gets about a quarter mile up ahead of it goes shorter. It has no compression. The cab driver backs down a little bit to get a running start. He can't get up to where he backs some more. Finally, he backs all the way down the hill. So I can't get up. I'm now 3 o'clock in the morning in the rain with 2 briefcases, walking 1 mile uphill. I'm not in great shape. It was really one of those nights you had to say, you've done something wrong to an article. You have to.
It just sounds like my flight was Douglas to your ordeal, but I had to laugh. I get on this plane to come here from Los Angeles. About to take off. Suddenly, the blue liquid starts coming down the aisle where the toilet had overflowed. And so we were on the ground for an hour and a half while they brought in ground crew, president of American Airlines, with thousands of people who were pouring into the back of the plane, so stand there, throwing blankets on the floor.
Resting on a very important portion.
Heard him, obviously.
You have to know that it's not flammable fluid.
David Letterman every night now. Every night, 6 months, he's saying, he turns to the band leader and says, Paul, there's a flight leaving from the airport. It's the 10 o'clock United flight to St. Louis. What time is that flight leaving? It's on the schedule. The 10 o'clock flight leaves at 12:20. And he continually has to keep bringing this up. Different flights that are scheduled to leave at a certain time, but are then sub-scheduled to leave at another time. Well, you must be driven crazy by things such as this. Being trapped. Well,
So, Bryce, I was once on such a horrendous flight to London. It's already, I don't know, about 12 hours. That once you go through something like that, I think that you'll see.
that's
So,
true.
My
Right.
parents are fully back with one of these. Halfway falsely home, somebody falsely bombs.
Ah,
They do